There are multiple misconceptions about the right to silence. In this video, I want to clarify and debunk 3 of the most common myths. Myth number 1, my silence to the police will suggest I'm guilty. Well, because you have a constitutional right to remain silent, judges and juries will not hear that you exercised that right and said nothing to the police. This is well established in our law. The fact is, there are many reasons you may choose not to provide a statement or to testify in court. A lawyer will be able to advise you as to whether or not it is in your best interests to provide a statement or to give testimony. However, not providing a statement does not suggest guilt, and your silence cannot be used to convict you at trial. The second myth I want to deal with is this. I have already said something to the police. My right to silence is now useless. Let me answer that by indicating that sometimes an individual may make a statement to the police before or during their arrest. They then realize that they had a right to remain silent that they failed to exercise up to that point. Simply because you made a statement initially does not necessarily mean exercising your right to silence is pointless. Your lawyer may be able to argue that those initial statements shouldn't be allowed into evidence because you were not informed of your rights or not given the proper opportunity to exercise those rights. The final myth that I hear so often is, I can explain away my circumstances to the police and the charges will simply go away. You may think that if you provide an explanation to police that you can make the charges disappear. There are 2 main problems with that belief. First, the more you talk, the more information you might reveal that hurts your case. By trying to explain away the charges, you could unwittingly be providing information to the police that further supports their case against you. Second, you may not even be aware that your explanation actually makes out the elements of the criminal charge you're facing. Let me use an example of the criminal offense of assault. Assault encompasses a wide range of activities including punching, pushing, slapping, shoving, and even spitting. In fact, a tap or a pinch could be considered a criminal assault in some circumstances. You may believe your actions could not possibly be considered a criminal assault, but the police, the prosecution, and the court may disagree. The same is true of many other offenses in the criminal code. By providing a statement that you believe exempts you from criminal offense, you could unknowingly be incriminating yourself. I hope that explains those 3 myths. Thank you for your patience.